Before a case ever reaches a jury, before anyone is forced to defend themselves at trial, the Constitution demands one thing first: probable cause. And in Harris County Criminal Court, Judge David Fleischer has made it clear that this requirement is not a rubber stamp. Today, we're stepping back inside Judge Fleischer's courtroom in Houston, Texas, where weak affidavits, vague allegations, and officer assumptions don't survive careful judicial review. Over a series of recent hearings, Judge Fleischer was tasked with answering the same foundational question again and again. Did the state actually present enough lawful evidence to justify criminal charges, or were they asking the court to do the prosecution's work for them? This episode is part of our ongoing effort to show how probable cause plays out in real courtrooms, not in theory, when evaluated by a judge who understands that constitutional protections are not optional, but mandatory. Each case we'll cover raises a different legal issue, but they all expose the same underlying problem: when allegations sound serious, but the evidence doesn't meet the statutory threshold required by law. We begin with a case that, on paper, appears straightforward.
You said that you did feel pain.
Read the full, the complete dim.
I wouldn't, or that's the problem, is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about, that the officer filed.
So the complete dims reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full dims, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full dim states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time you're in the stress of the excitement, so you're not feeling it. But then after
That's not what she said though, or that's not what
Stress.
they're going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that document.
To be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer
That's not in that.
asked, but the officer never asked, hey, do you feel pain? Why
And
wouldn't you
because the
ask?
officer never asked, he came to the conclusion based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough, because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not alleged the pain as an element, but taken as a totality.
I guess you're saying
No.
taking it as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that
You
connection.
don't operate on hunches.
Right. And she's also stated that I was fighting him. So that could be because of her fighting.
I mean, here's the deal. Like if I find no PC, right, they may just re-indict it though.
That's fine.
No.
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on body worn camera, he never says, we don't know.
But well, I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there are visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, I do
You
it
know?
all the time. If you fall downstairs and you're embarrassed more than in pain. You might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if we
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element. So maybe the grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. If we want to re-indict it, we can.
Okay, all right, I'll find no PC. Okay.
Defense counsel James Pons zeroed in on the weakest link in the state's case, the alleged bodily injury. Under Texas law, bodily injury requires actual physical pain, illness, or impairment, not speculation. Mr. Pons argued that the complainant's own statement defeated the charge. She explicitly told the deputy that she did not feel pain, and aside from the officer's personal assumptions about what must have caused pain, the state presented no evidence to satisfy that statutory requirement. Judge Flischer agreed. He made clear that probable cause cannot be built on an officer's beliefs or generalized training when the alleged victim's account contradicts that conclusion. Without evidence of actual pain, the essential element of bodily injury was missing. As a result, Judge Flischer found no probable cause, and on February 5, 2025, the state dismissed the assault charge entirely. The next proceeding raised a very different constitutional issue. On September 26, 2024, Jananisha Winbush was charged with interfering with public duties under Section 3815 of the Texas Penal Code. That statute criminalizes actions that interrupt, disrupt, impede, or otherwise interfere with a public servant while they are lawfully performing their duties. But the law also draws an important boundary. It expressly provides that speech alone cannot form the basis of criminal liability. A probable cause hearing for Men's. Winbush was scheduled for October 3, 2024.
Street in Harris County, Texas, regarding a disturbance. The officer made contact with the individual causing the disturbance, and the defendant approached asking officers what's going on and what did she do. The officers repeatedly asked the defendant to step back, and she became belligerent, asserting that they were at her store. She eventually complied and moved away, but she insisted that a police supervisor be called to the scene. TSU Sergeant Barnett arrived and spoke privately with the defendant. Afterwards, responding officer requested the defendant's information to report her behavior to her supervisor in the university. The defendant refused to provide it and attempted to bypass the officer. When the officer asked her to identify herself again, the defendant declined and attempted to walk away. As the officer tried to detain her, she began to throw herself on the ground and yell, escalating the disturbance. Several officers issued verbal commands for her to comply. The defendant continued to resist, jumping around and asserting her rights. The officer attempted to escort her outside. The defendant then wrapped her arms and legs around a pole, continuing to yell. The officers physically pried her from the pole and detained her. The defendant used her body weight to resist and push against the officers. The defendant was then placed in the back of the patrol car without incident.
What was she doing wrong?
So it appears she wasn't the initial person causing the disturbance, but when they came to respond to the disturbance that they were called for, she intervened. And once they asked her to remove herself from the situation, she refused.
You didn't say, when you initially started saying about everything, you didn't say that she was the initial cause of the disturbance, that there was a call for a disturbance. They get out there and she, I guess.
So what it says is that they made contact with the individual that was causing the disturbance, and then the defendant approached asking.
See,
the officer.
right. So she just comes up, starts being nosy, right?
Right.
And then she basically, I guess, is trying to leave. And then they start asking her for her information.
Well, they were asking her to leave the scene so that they can respond to the disturbance, and she wouldn't comply. I think that's the issue, that she wouldn't leave when
Did
they asked her.
you say that?
Yes. They asked her to move away from the scene and she refused to comply.
Show me, will you read that part again?
So when she approached the officers repeatedly asked the defendant to step back, and the defendant became belligerent, asserting that they were at her store. She eventually complied and moved away, but
So she complies, she moves away,
right. But then she came back.
okay?
And so at that point, when she returned, they asked her to identify herself. She refused to provide her identification. And then at that point, when they asked her to identify herself, she attempted to bypass the officers.
She leaves, she's trying to leave.
She is attempting to, yeah, she's
She's leaving.
attempting to leave again.
And then they start bucking up to her.
Sure, yeah.
Judge, what is this case?
It's on for tomorrow's docket. Let me give you the cause number. 251-1137.
Sounds like interference. So
That's what she's charged with. But, so, sounds like she's got a case of the nosies, you know? She goes up there allegedly being nosy, she leaves, comes back, and then they start asking for her information. And she declines to give her information.
So Judge, what I'm looking at here, just to add context to the situation, she approaches in an unrelated incident, it looks like.
Correct.
She's asking what's going on. Fine. They talk to her individually. Okay. They tell her to leave. She continually asks what's going on. What did she do? She asserts, she becomes belligerent, is what the officer says, asserting that they were at her store, obstructing their investigation. Eventually, I don't know what the time frame is, but they say eventually she complies, moves away, but insisted that they need to call a supervisor to the area. A sergeant then spoke with her privately. After they responded and they requested her information to report her behavior to her supervisor at the university, and to identify her, which she refused to do. She then attempts to bypass officers. They ask her for identification again. They're detaining her. She says no.
But what's the interference? What did she specifically do?
Well,
She's just talking to them.
I understand,
Right?
Judge, she's talking to them, but she's saying that they're at her store. She's belligerent,
So?
telling them to leave. They're at her store. The position of the state judge is that did obstruct their investigation. I mean, it's not in this, there's multiple senses of obstruction in our opinion. It's not.
Are you losing right now? Okay. Yeah, I'm not buying it.
Okay.
I'm not gonna do it.
After reviewing the allegations against Ms. Winbush, Judge Flischer made it clear that the state had stretched the statute too far. Whatever frustration or verbal resistance may have occurred, her conduct did not meaningfully interrupt, disrupt, or impede a public servant's lawful duties. More importantly, the evidence showed no action beyond what the law explicitly protects. Without conduct rising above speech or passive behavior, the charge could not survive even the low threshold of probable cause. Judge Flischer therefore entered a finding of no probable cause, and the state dismissed the case the very same day. The next probable cause ruling we're examining follows a similar statutory theme but unfolds in a far more emotionally charged setting. On January 26, 2025, Wall Kemp was charged with interference with public duties after an encounter involving emergency medical services. According to the allegations, Mr. Kemp briefly grabbed the arm of an EMS responder while the responder was transporting his mother, who was experiencing a medical emergency, to the hospital. Defense attorney Carolyn Okorafor was appointed to represent Mr. Kemp, and a probable cause hearing was held on February 6, 2025, once again in Judge Flischer's courtroom. This case would force the court to confront a critical question. When emotions run high during a medical crisis, where does the line fall between understandable human reaction and criminal interference under Texas law?
So what's the word, Thunderbird?
So upon watching the video, I agree with the offense, but it's not really clear. It's all happening at once where you see one moment, the defendant like lunge forward, but blocked. You can't see what he does. And then officers grab him immediately. So you really can't see the grab that the officer says in the OR that occurred. But in the OR, it says there was that grab, and that's why they grabbed him back. So
It's not there, it's not there.
Not there.
you just can't see. It's not saying it's not there. It's just that you can't see it on video. It's obscure. There's people in the way because
So I guess my theory from reading the notes is that when the whole situation was happening with his mother, the gurney was left outside of the house. So the EMS never came inside the house. They were asking the son who opened the door the mother has to walk outside. And he was like, my mother can't walk outside because she's having trouble breathing. Mom eventually comes outside, gets on the stretcher. The stretcher is then taken into the ambulance. The son is running after the stretcher because they're trying to make sure that their mom is fine. What the commotion that arises is that, for me, I feel like nobody knew who exactly pushed who, but it's more of an emergency situation about a child caring for his mom who's having a serious medical issue.
I mean, times like this, when you have a medical emergency, right, it's always chaos. I mean, there's chaos ensues, right? Is he really trying to prevent an EMS person from doing their job?
So you look at the totality of the facts, it's like, how are you supposed to, how is he trying to prevent someone from doing their job when all he's trying to do is make sure that he's helping his mother, who they said, hey, we're not going to come to the house to even bring you in.
Does he pull the arm off?
according to the officer, he just grabbed it and the officer grabbed him at that point. So the reason why it's not really clear how quick it happened. On the video, it looks pretty quick because the officers grabbed him immediately.
But
So,
but the issue is that the officers arrive at the scene when there was already an incident occurring. They don't know, the officer can't state what happened initially.
right, but the issue here is that as it's played, it's like the grab of the arm is that interruption or just disruption of the EMS trying to get the mother onto the gurney. And it's not necessary that the defendant intended to do that. It's just that there was that
This is a
disruption.
specific intent crime, so he has to specifically intend to interfere with the duty of that person, of the performance and exercise of what the official is trying to do. That's what he's charged with. Right?
Respectfully, this is a criminal negligence. There's no intentionally knowingly requirement for this. It's just that a disruption occurred through the defendant's actions with criminal negligence. So in this case, he grabbed the EMS and the negligence would be that a reasonable person should have known not to do that, and that therefore resulted in the disruption of the EMS trying to perform their duty.
But the negligence also didn't pose a serious harm or threat. Like the EMS didn't appear to be threatened. I just don't think it's enough. I mean, even if they were to give us an offer, if we take this case literally to trial, the mom is going to testify as to what happened, including the brother and the dad, because they were also witnesses, which I spoke to all of them. I mean, I'm saying are we going to drag it? Because I just don't see it.
Our position would be that there's enough to move the case forward with probable cause. Whether there's issues for trial is another issue.
I mean, in that sense, he's right. I mean,
Yeah.
it's just a probable cause hearing. Is there enough to move forward? Because it's a very low burden, right? Yes, I agree with you. Is it enough to find someone beyond a reasonable doubt guilty? Perhaps not.
And I'm also basing my arguments as what is actually the evidence that we currently have to kind of figure out the confusion on what actually happened that night. Because the video's not clear at all, which sucks.
Videos are not clear, so admittedly, our reliance is on the sworn statement by the officer in the DIMS.
So let's look up, because it says here, by grabbing EMS responders' right arm, interrupt, disrupt, impede, and interfere with Sanders, a person employed to provide emergency medical services, including the transportation. I'm sorry, this is what I'm looking at. Did then and there unlawfully with criminal negligence. What does criminal negligence mean? Let's look it up.
Yes, Judge.
The defendant should have been aware of a substantial and unjustifiable risk of harm. Is there substantial and unjustifiable risk of harm in this case?
One moment, Your Honor.
The risk must be so significant that it's a gross deviation from what a reasonable person would do.
I mean, I'm going to argue that if he was briefly grabbing the responder's arm, it does not create substantial or unjustifiable risk of harm. Meaning the fact that due to the nature of the situation, he was acting emotionally.
And Your Honor, if we're gonna go that, I'd respectfully ask for maybe 5 minutes to look in case law and see.
Take your time. There's no.
Yes, Judge.
Yeah, absolutely. There's no rush here. I mean, we got,
Yes, Judge, I respect 5 or 10 minutes and just to look at. case law.
Absolutely.
Yes,
Take your
Judge.
time. Okay. Once and for all.
Yes, Judge, and after reviewing the video and reading case law where there's a case Duncan Tel v. State where they describe it as essentially shutting down, even we looked at it, and we don't see that here.
Okay, I'm gonna find no problem.
Yes, Judge.
All right.
Yes, Judge.
All right.
Your Honor.
Good job.
Thank you, thank you.
And I'm gonna tell you, look, from what I read, I was looking at case law as well too, and it said the gross deviation is such that like, there was a guy who had a trailer, right? Who didn't put chains on the trailer detached, it was a homemade trailer, it detached and it killed someone. That's a gross
That's why I
deviation, you know what I
posted the
mean?
video and it was just
Yeah.
very brief. Yes, Judge.
You have enough cases.
Yes, Judge. Mhm.
Thank you, Your Honor.
Thank you, Judge.
When the prosecution circled back to the excluded video, Judge Schroeder stopped the proceedings again and cleared the courtroom. That alone tells you how serious the issue had become. This wasn't confusion. The court had already ruled. The video had been addressed, analyzed, and excluded before trial ever began. So to understand why Judge Schroeder reacted so sharply, you have to understand what that clip actually represented in legal terms. The problem wasn't relevance. It was purpose. The video wasn't being offered to explain what happened in Kenosha. It wasn't tied to the specific encounters that led to the shootings. Instead, it invited the jury to draw a much broader and far more dangerous conclusion, that because of something Rittenhouse said weeks earlier, he was the kind of person who would commit violence. That's exactly what the law forbids. Wisconsin law sharply limits what's known as other acts evidence. You can't introduce a defendant's prior behavior simply to suggest bad character or a violent disposition. The rules allow exceptions: motive, intent, preparation, absence of mistake. But those exceptions require a direct and legitimate connection to the charged conduct. Judge Schroeder found that connection was missing here. The video didn't clarify intent at the moment of the shootings. It didn't explain decision-making under pressure. It didn't establish preparation tied to the events in Kenosha. Its only real effect was to poison the well, to encourage the jury to reason backward from character instead of forward from evidence. That's why it stayed out. So when the prosecution raised it again during cross-examination, the issue wasn't just evidentiary. It was structural, allowing excluded propensity evidence to seep into questioning risks, undermining the fairness of the entire trial. With the jury excused, Judge Schroeder addressed the matter directly, reinforcing a principle that sits at the heart of criminal law. Defendants are tried for what they did in the charged incident, not for who the prosecution wants them to appear to be.
Tell me, what's up?
I wanted to see if we could get a PC for Samuel Duto.
Okay, sure. Okay, so is he in custody?
Yes, he's currently in custody.
So he's got two cases. He got the theft and the failure to ID.
Yes.
Which one are you challenging?
Failure to ID.
On September 13th, 2023, at approximately 3:22 in the morning, officers were conducting routine patrol at 7-Eleven and the alley behind the 7-Eleven, which is a common place for drug activity, graffiti, panhandling, and transits hanging out. They noticed a person using the wall plug-in on the outside of the business to charge his cell phone. Officers made contact with the person and asked for his identification. The suspected charge is theft of a service under Penal Code.
Oh, come on. They charge him with theft because he's trying to charge his phone?
No, they didn't charge him with that, Your Honor. This is the,
I know, but that's the contact to get to him.
yes.
There's nothing mentioned in that in the report. When they approached them, there was no indication that the owner said that they didn't have permission to be there. There was no indication to say that they did not receive permission to charge their phone. They approached them for what?
Your Honor, it's not common that a store clerk would offer someone the opportunity to charge their phone in the alley behind the 7-Eleven as opposed to within the 7-Eleven itself.
Just because it's not common doesn't mean that you can't have it.
And so what, so they go up to him, they start talking to him,
He identifies himself as Vinny Mancuso, birthday 3/19/1991. Then he stated his name was Samuel Mancuso, same birthday. He was unable to verify each one of those, and another officer eventually located his wallet and identified himself by his true name, Samuel Duoto.
They were doing nothing.
Defendant had outstanding warrants and was placed in custody.
What? They was.
He was charging his phone when he
What do you think? Charging his cell phone, so they come up to him and they start talking to him, and then, I mean, come on. Talk to Pavel, let's see.
Judge, we'll defer to the court. I mean, he didn't have a warrant for his arrest, so.
I mean, he's stuck anyways, right? Because the theft is good. He's not going anywhere, right, on the theft. So,
When he's charged, it sounds like it's PC, but we'll defer to the court. Because he had a warrant for his arrest. I mean, that's.
do you want to do something with it today anyways?
We weren't. We had something worked out. I didn't like the fact that,
Because it might happen anyways.
I
You know
wanted
what I mean?
time served. I wanted the time served. He offered, he would have to do 24 more days.
I'm okay with that, or I'm okay with whatever you want. It's up to you guys.
Yes, Your Honor. I'll always defer to Pavel with things. After 90 days, depends once time served.
Okay, and I'm totally fine with that too.
Okay, thank you. All right,
Thank you.
we'll came up here. Thank you.
Hey, Alan. Okay, so first we have, is this that's Rivera and Soto?
With the D.
Oh,
I
Duarte,
can't- I know
right.
I mispronounced it, so. Pronounce it one more time?
Duto.
Yuto.
Be careful when you charge your phone. You now know they're gonna mess with you anytime, even going to a 7-Eleven, you know what I mean? Be careful, right? So, sir, you're charged with 2 cases. You're charged with failure to identify oneself. You're also charged with theft. Alan, what are we doing on this?
I believe we're going on the failure to ID and dismissing the.
Dismiss the theft?
Yes, Your Honor.
Okay, that is a fantastic deal, Mr. Duato. I hope that you understand this and appreciate it, you know? Most times people plead to the theft case and it really hoses them. Because then you're looking at, you know, federal, or not federal, but felony time next time. So you're charged with failure to ID. It's up to a year in jail and or a $4,000 fine. They've offered you time served, 18 days in jail, credit for the 6 days that you've done. You're giving up a lot of rights by entering this agreement, and same goes with you, Mr. Rivera. You both give up a lot of rights by entering these agreements. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Now, Mr. Rivera, you're charged with assault of a family member. You need to understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you'll be facing a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Have you ever been to prison before? It's not a fun place, man. You can never own a gun or ammunition as a result of this plea bargain agreement as well. You picking up a gun is a Class A misdemeanor in and of itself, okay? What time are we looking at on Rivera? 21/7? Okay, so it's 21 days in jail, credit for the 7 days that you've already done. How do you plead to the offense, sir? Guilty or not guilty? I will find you guilty, sir. And Mr. Rivera, how do you plead? I will find you guilty as well. I will roll both of your court costs so you won't owe anything, and good luck to you guys. All right.
All right, gentlemen, go ahead and go through that door for me.
Assessed on a quiet day in a courtroom, a defendant stood before Judge Fletcher facing 2 charges, theft and failure to identify himself to law enforcement. On the surface, this seemed straightforward. A man accused of stealing. A man who gave police a false name. Open and shut, right? But Judge Fletcher saw something else. Something that would unravel the entire case. Because before we talk about what Mr. Duoto did or didn't do, we need to ask a more fundamental question. Did the police have probable cause to stop him in the first place? Sure yes. Here's what most people don't understand about probable cause. It's not just a legal formality. It's a constitutional shield between you and the power of the state. The Fourth Amendment to the United States Constitution protects citizens from unreasonable searches and seizures. That means police can't just stop you, detain you, or arrest you without a legal reason. They need what's called probable cause. A reasonable belief based on facts that you've committed a crime docta cessers, and this is where Judge Fletcher's courtroom became a constitutional battleground. The prosecution argued that Mr. Duoto had committed theft, that he'd lied to police about his identity, that the case was clear. But Judge Fletcher wasn't convinced. He looked at the facts carefully, very carefully, and here's what he found. The detention itself, the moment police stopped Mr. Duoto, may not have been lawful, Doc. Think about that for a second. If the initial stop was illegal, then everything that came after it, the questions, the investigation, the charges, all of it could be tainted. Fruit from a poisonous tree, as lawyers like to say. Judge Flischer didn't just rubber stamp the charges. He did what every judge is supposed to do. He examined the evidence. Did the facts alleged actually satisfy the legal elements of the offense charged? In other cases before his court, he'd asked similar questions. When someone was charged with assault, was there really quote-unquote bodily injury? Or just bruising without pain? When someone was accused of interference with police, was there actual obstruction? Or just verbal opposition and brief physical contact? For us, these aren't minor distinctions. They're the difference between guilt and innocence, between prosecution and freedom. In Mr. Duoto's case, Judge Flischer expressed serious doubts. If the detention wasn't lawful, then Mr. Duoto had no legal obligation to identify himself. And if he had no obligation to identify himself, then providing a false name wasn't actually a crime. The foundation of the entire case was crumbling, but here's what happened next. Despite Judge Flischer's doubts, he didn't enter a formal finding of no probable cause. Instead, Mr. Duoto accepted a plea agreement. He pled guilty to failure to identify in exchange for the theft charge being dismissed. Now, you might be thinking, wait, didn't the judge just say the detention might have been unlawful? Why would Duoto plead guilty? Welcome to the reality of the American criminal justice system. Sometimes, even when you might win, the risk of losing is too great. A plea deal offers certainty, a trial offers a gamble, but this case, and others like